Pension schemes are particularly rich in data, very valuable data too, with huge costs attached to any leakage or loss. A new data protection bill going through Parliament right now will transform the way organisations deal with personal data. Data subjects, like you and I, will get new rights. Data controllers, such as pension scheme trustees, and data processors, such as administrators, will have to be more transparent and more accountable because there are much higher fines for getting it wrong. And the clock is ticking. The new regime applies from the 25th of May this year. The bill is designed to implement the General Data Protection Regulation, or GDPR, which specifies that personal data shall be processed lawfully, fairly, and in a transparent manner. It needs to be collected for specified, explicit and legitimate purposes. It must be adequate, relevant and limited to what is necessary, with time limits set by the data controller for erasure or periodic review. It has to be accurate. Data must be kept in a form that permits identification of data subjects for no longer than is necessary. And it must be protected against unauthorised or unlawful processing and against accidental loss, destruction or damage. All organisations will have to thoroughly review how they handle personal data. The good news is that planning is well underway in our industry. Although it is the data controller, i.e. the trustee, who is responsible for compliance, in most pension schemes it falls to the administrators to implement the controls. I'm not going to attempt a comprehensive overview in a few minutes. And instead, I want to just focus on what lawful processing is and what is actually necessary in a pension scheme. There's a fairly common belief that data subjects must give explicit consent to use of their data. But consent is only one of the grounds for lawful processing. There are 5 others. These are where processing is necessary for the performance of a contract to which the data subject is party, or in order to take steps at the request of the data subject prior to entering into a contract, for compliance with a legal obligation to which the controller is subject, in order to protect the vital interests of the data subject or of another natural person, for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller, or for the purposes of the legitimate interests pursued by the controller or by a third party, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subject, which require protection of personal data, in particular where the data subject is a child. While it might be a common practice to obtain and record consent upon enrolment of an individual into a pension scheme, it seems to be generally recommended that consent not be relied on because of the potential difficulties in demonstrating a freely given, specific, informed and unambiguous indication of the individual's wishes in every situation. Fortunately, the bill includes a specific relaxation for occupational pension schemes. Consent is not required for processing data to determine eligibility for a scheme or benefits payable, provided it's not for the purposes of measures or decisions with respect to the data subject, and the controller cannot reasonably be expected to obtain consent and is not aware of consent having been withheld. What is necessary will be purpose-specific. For instance, the Money Laundering Regulations 2017 make provision for record keeping by trustees, as do the 1996 Scheme Administration Regs. Automatic enrolment duties carry certain requirements to allow employers to demonstrate compliance. The FCA requires some firms to retain records indefinitely in relation to pension transfers, pension conversions, or pension opt-outs. The question of how long data can or must be kept is a challenge for organisations which would like to impose a single framework across all activities. I've heard of one case recently where it was proposed to interpret no longer than necessary as 7 years, possibly derived from the statutory minimum period for data retention under tax law of 6 years. And yet, as we know, A pension scheme may need to keep data for 50 or 100 years until the last dependent's benefits are paid following a member's death. I've only covered a few aspects of the GDPR challenge we face. You'll find the full lowdown, for example, on the special constraints that apply to processing of sensitive personal data, on our website. Just click the link below. But don't leave it too long. Remember, the clock is ticking.